So we're going to move away from trademarks now, away from Team Broti to Team D Croti, and focus on designs and copyright. We'll hear from Toby, Jake, and our first speaker, as Mark identified, thanks to the slide, is Senior Associate Sean Ibbotson. Special thanks to Sean, because he's expecting his third child any moment. So I would say, if you do get a call from Jenny,
I've got my phone out.
make sure you complete the presentation and leave in an orderly manner. Thank you, Sean.
So I am here today to talk about the water rower case. So we've been in the Court of Justice and the Court of Appeal. We're now going to dive into the depths of the IPEC, and not even a final decision at the IPEC, an interim application hearing, a strikeout application, and not even a real judge, a deputy judge. So what are we doing down here? Well, despite the lowly status, we think this is one of the most interesting copyright cases of certainly last year and possibly the last couple of years, and it's really useful for highlighting some quite stark inconsistencies between UK and EU copyright law at the moment. So some background. Claimant created this wooden rowing machine, exercise rowing machine made out of wood in the 1980s. There's only one picture on the slide you'll notice, and that's because the defendant's wooden rowing machine was described by the judge as basically a replica that had been copied from the claimant's. And so unsurprisingly, the defendant had actually admitted infringement for the purposes of these proceedings, but it denied that copyright subsisted in the rowing machine. So the only real issue that we're worried about today is whether copyright subsists. Because of the inconsistencies in UK and EU copyright law, which I'm going to talk about in a moment, the claimant's case was kind of based on two different arguments. Basically that its wooden rowing machine was protected as a work of artistic craftsmanship, a WOAC, under section 4.1c of the CDPA. And then alternatively, as a work protected under the CDPA, but kind of as interpreted in light of recent CJEU judgments, and in particular Cofamel and Brompton. I say recent, they're actually now 3 or 4 years old, but relatively recent. One thing to bear in mind is that this was a strikeout/summary judgment application, and so the judge's findings in relation to copyright aren't that copyright subsists in this wooden rowing machine, but that there's a decent prospect that when they get to trial, the claimant will succeed. So the test he was applying was whether the case was kind of obviously ill-founded or bound to fail. So as I said, two different approaches to copyright law, in particular kind of for 3D objects like this rowing machine. The case is nice because you get a kind of side-by-side comparison of UK and EU law, and so we can look at the two approaches here and contrast them. So the main argument was that the rowing machine was a work of artistic craftsmanship, and there's some evidence before the court in terms of the creator's artistic intentions and kind of the perception of the object since, and so that was the evidence that was relied upon. So we can kind of go through the test in the few steps that there are. So work of artistic craftsmanship is one of the closed categories of works within the CDPA, and there's no definition in the CDPA of what a work of artistic craftsmanship is, but it's been interpreted by some quite big authorities over the years. So the main case on artistic is Hensher, which is approaching 50 years old now, a case before the House of Lords, which considered some prototype furniture. And it's fair to say it's a complicated judgment, and the judge, even in Water Rower, kind of refuses to summarise it down into a pithy statement, so I'm not going to try to do so either. But what he does do is pick out some key themes from the judgments in Hensher, and then kind of applies those to the Water Rower, and whether or not it satisfies that test, if that's the test that's to be applied. So some of the law lords in Hensher, I should say to start with, that there's a unanimous decision in Hensher that this piece of furniture was not protected by copyright, but they came up with multiple and inconsistent reasons as to that decision. So some of the judges in Hensher said that being a work of artistic craftsmanship might depend on the creator having some artistic intentions. And in this case, the evidence before the court was that the creator of the rowing machine did have some artistic intentions, so he wanted the rowing machine to be kind of engaged with emotionally and to be kind of seen as a piece of furniture in someone's house. So there was a decent prospect that the claimant would satisfy that test. Four of the law lords in Hampshire also said that there needed to be kind of something more than eye appeal in order to qualify. They weren't clear what that more was, and in the water rower case, the judge, David Stone, kind of speculates that maybe it's about how the object is perceived after it's been launched. And in this case, there was evidence that the water rower had been recognised by the Museum of Modern Art. It appeared in the Design Museum in London, so maybe it did have kind of more than just eye appeal. And then finally, there was one of the law lords in Hampshire set out a list of items that might qualify as works of artistic craftsmanship. And that list included some things which were functional, so iron gates and some cabinets, and said that they could potentially qualify as works of artistic craftsmanship. So there was nothing in Hampshire that kind of disqualified the rowing machine from qualifying for copyright or being an artistic work. Craftsmanship is considered in Hampshire, but actually it's all over. So the main judgment on craftsmanship is actually Lucasfilm. And the test in there, the judge was satisfied as well with, which is that it was created by a craftsman as opposed to a slavish copier. And again, there was evidence before the court that Mr. Duke, who had created the wooden rowing machine, had kind of gone at it very skillfully and created bits of it by hand. So that actually on its own would have disposed of the strikeout application. The judge wasn't saying that the wooden rowing machine definitely was a work of artistic craftsmanship, but just that at trial there was a realistic prospect that they would satisfy the court that it was. So despite that, and because of this alternative argument about EU copyright law, the judge then went on to consider whether, on the alternative argument, it would also satisfy the test as a kind of a work as interpreted by recent CJ EU judgments. And this is really nice because, as I said, it kind of highlights the complete inconsistencies between these two approaches. And the EU judgments, Cofamel and Brompton, do remain part of the UK's copyright law because they are retained EU law as a result of Brexit. And so courts, including this one, everyone below the Court of Appeal is bound by that retained EU law. So what are the requirements under EU law? So Cofamel does two main things, really. The first is that it precludes member states, which we were at the time, from having national copyright laws which require an object to have a kind of specific aesthetic effect in order to qualify for copyright infringement, Now that's clearly completely inconsistent with everything that's going on in Hampshire, and so it's possible to reconcile the two. What Cofamel says is that there are only two real requirements for copyright subsistence. The first is that the object is original, and that means that it reflects the author's intellectual creation. It shows that there's been some free and creative choices. And the second is that there's an expression of that creation, that you can kind of identify the work with sufficient precision and clarity and objectivity, and that's to rule out kind of taste and that kind of thing. So that is a very permissive, relatively low threshold for copyright subsistence. The other kind of recent CJ judgment that is relevant here is Brompton, which is to do with the folding bicycle. But all that does really is say that functional objects, such as a folding bike, can in principle be protected by copyright, provided that they meet the test in Cofamel. So why is this case interesting? Like I said, there's clear inconsistencies between the UK and EU approaches to copyright subsistence. And the one we focused on today in this case is the aesthetic requirements in the CDPA for a work of artistic craftsmanship and how that conflicts with Cofamel. But it's also really difficult to reconcile Cofamel with the whole UK approach to copyright in terms of having a closed list of categories, each with different requirements for particular types of works. That seems to be completely anathema to Cofemel. These tensions remain unresolved. Like I said, Cofemel's 3.5 years old now. So why is that? One of the reasons is that, as we all know, disputes settle before they reach trial. So there was an interesting case in the pipeline that we were aware of about 18 months ago to do with the Bodum coffee press, French press that you can see on the right. The claimant there was alleging that their design creation was protected as under the principles in Cofemel. That dispute settled, so it never reached trial. We've also had a few, it's hard not to be too harsh, but judges kind of dodging the question, basically. So in Response Clothing, there was a similar argument about this fabric design on the right-hand side of the slide that you can just about see. The judge in that case kind of dodged the question by saying that it qualified as a work of artistic craftsmanship, so he didn't need to decide the kind of inconsistent approaches and which one was the right one. In Water Rower, I've got a bit more sympathy with the judge in dodging the question here. He said it's one that might arise at kind of trial. His job on the day was just to say whether or not the claim was liable to be struck out, and he said that it wasn't, so he kind of declined to decide the issue. But this quote from the judge is quite interesting. I'll leave you with this one. So he says, the interaction between the CDPA and Cofemel is not a simple one. It would appear to need to be resolved at some stage by Parliament or the lower courts or the higher courts. Everyone else has done a takeaway, so I think I should probably come up with one too. And I guess the takeaway from this is that if you'd like to be involved in a test case, and you have a 3D object that you think is protected by copyright, then it would be a good time to bring a claim, I guess, but you might end up being dragged through multiple layers of courts in the UK before you find out what the outcome is. But that might be an attractive proposition, or it might not be. That is all I've got, so I'll hand over to Jake.
So I'm going to be presenting on the Only Fools and Horses case. So this was a copyright infringement and passing off case that was largely focused on copyright, so I'll be doing the same. And Only Fools and Horses is a TV show that aired on the BBC from 1981 to 1991. It centres around Del Boy and Rodney, who are two brother market traders in London in the 1980s and 90s. And the scripts for it were written by John Sullivan, who passed away in 2011. So his family company are called, or his family's company are called Shazam Productions, and they own much of the IP in Only Fools and Horses, and they're the claimants of this matter. The defendants were kind of a group of different individuals and entities that in 2018 developed a interactive dining experience called Only Fools, the Kushti Dining Experience, without any sort of license from Shazam Productions, hence the dispute. And essentially what this was diners would be given a 3-course meal, and they would be shown, and live actors would perform scenes from a script that the defendants had written, and they would reenact many of the characters that you can see on the left from the original show. And it was actually these scripts that were the focus of the copyright infringement element of the case. So it was a very long judgment, and I'm just going to focus on the findings in bold, which makes it look like I'm dodging a lot. But just to give you the context, the claimants relied on 3 different categories of copyright work. So first of all, they claimed copyright in the episode for each, or the script for each individual episode, and the judge was fine with that, said that was a dramatic work and that was infringed by the dining experience. They also tried to rely on the body of scripts as a whole, which represented the world of Only Fools and Horses. But the judge didn't like this so much and said that was not protectable as a separate body of work. And the main reason, he didn't get into it too much, but the main reason for this was each episode was kind of its own discrete story, rather than like a continuous flow of stories, or continuous flow of one story. Finally, and most interestingly, they claimed copyright in the character of Del Boy, and the judge found that he was a literary work, and that 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 work was infringed by the dining experience. Now, the reason infringement isn't particularly interesting in this case is because the dining experience, the evidence showed that the dining experience, their whole intention was to try and make attendees feel like they were in an episode of Only Fools and Horses. So it would have been a bit odd for them to find that Del Boy was a protectable copyright work and then not find that that copyright was infringed by someone who's doing their very best to portray a Del Boy. They tried to rely on parody and pastiche as defences, but these both failed, and I'll get into those later. And passing off was found, and yeah, we'll get into that, but in part because the claimants were running a musical in the West End at the same time, and this meant there was likelihood of a diversion of sales. So the reason this case is so interesting is the UK courts have never really dealt with copyright in a character directly, and much of the obiter commentary from other cases or commentary and practitioner's text was kind of not given much weight at all by the judge. The judge did give a bit more weight to other jurisdictions. So on the left, that's Germany. They found that there was copyright in Pippi Longstocking, and similarly in the US, they found that there was Sherlock Holmes and Dr. Watson were copyright protectable. And there they kind of focused on the distinctive features that each of the characters had. And so the word distinctive appears quite a bit in the judgment because the judge kind of tried to relate that to Del Boy. So on to Del Boy himself. Given that there was no binding judicial authority on the judge, he kind of went back to the basics of which Sean has helpfully laid out in that presentation before, of the Coffermel test, and then he kind of followed that with, and which bucket am I going to put that in terms of and eventually deciding a literary work for the purposes of UK law. But much of it was about Coffermel and undergoing that two-step test. And essentially what happened was the claimants relied on 5 key features of Del Boy's that they said were original, identifiable from the script, and copied in the dining experience. I'm not going to go into each one. The judge did, and kind of explained why, although they may sound vague, why they were fundamentally important to the character of Del Boy. So just taking the mangled French as an example, him using French incorrectly went to the root of his character because he was trying to convey an air of sophistication about himself. And the fact that he then got the French wrong was ironic and comedic and kind of to the root of his character. But the judge was also careful to say that each of these may sound vague, but together they formed this quote he's got here: a fully rounded character with complex motivations and a full backstory. And then on identifiability, the question here was basically, can you objectively identify these features from the script? So it's not how someone reading the script feels about Del Boy or feels how he is. It was clearly anyone reading the script would appreciate that he is, for example, eternally optimistic, which is one of the key features. And as I said before, the judge then very quickly just kind of decided he was a literary work rather than a dramatic work, without going into too much detail. So the defendants then had to rely on Section 30A of the CDPA, and they had to claim that the dining experience was a parody or a pastiche. And to kind of satisfy 30A, you need to show 2 things. So first of all, that the infringing work, let's call it, is either falls within the definition of a parody or a pastiche. And then secondly, you need to show that it satisfies the fair dealing requirements. And I'll get onto parody and pastiche next, but it also failed on fair dealing because the judge gave quite a few reasons, but just to name a few, he said that steps 2 and 3 of the fair dealing test weren't met on the basis that of just the extent of the copying from the dining experience, from the original show by the dining experience was one factor. Also, it plainly competes, given in particular the musical that was in the West End at the time. And then finally also said that the dining experience itself doesn't really engage any fundamental rights that are necessarily worthy of protection or balancing. So, for example, like freedom of speech for political criticism or something like that. So then on to parody. The judge distinguished between two types of parody. So first of all, you can have a parody of something. So this is where the copied work is mocking or critically engaging with the original work. So an example he gave was, this was way before my time, but it was a BBC sketch, The Two Ninnies. I hear some chuckles, so some recognition maybe. But then, so that was directly mocking the original source content of the two Ronnies, Ronnie Corbett and Ronnie Barker. And it was directly engaging with those scenes by making fun of how they were portrayed. The second type of parody is parody with or target parodies. This is where the copy is using features from the original work, but it's not actually making fun of the original work. It's got some other target in mind. And a good example of this came before CJU and Deckman and Vandersteen. And you can see here how the image on the right, which is the copy, takes a lot of the features of the original on the left, but it's not actually targeting, well, the facts of the case, but it wasn't actually targeting the publication on the left. What it was targeting was it was criticising the political figure that it's depicting and shown on the right. But anyway, that's a long way of saying the important thing to remember for parody is that it has to have some target, whether it's the original work or something else. And the dining experience didn't have either. It wasn't making fun of of Only Fools and Horse. It was more of a homage to it. It was paying respect and trying to be as close as possible. And it wasn't making fun of anything else either. And then on to pastiche. Again, there's two types. So the first is where you're imitating the style of another work. So the example on the bottom right might be an example. I don't know if that would necessarily satisfy the test. And the second type is being a medley of a number of different pre-existing works. So the UK IPO actually helpfully gave an example of that, of taking clips or various clips from various films and then compiling them into a new artistic work. But in either case, the copied work needs to be noticeably different from the original content. And here, again, the dining experience just fell well short, it seemed. They were just taking wholesale the characters and their backstories and reproducing them in their scripts, so they seem to fall well short. So on to takeaway points. The main one is that copyright can now subsist in a character according to this judgment. What's quite interesting is because Del Boy is such an iconic and distinctive character, he was kind of the perfect character to kind of kick down the door open to copyright subsistence in the UK courts, but he wasn't really a great test case in some ways, so it's hard to know where the limits and boundaries are at this stage, because the judge even said he had no hesitation finding originality in Del Boy. So what will be very interesting is if in the years to come we get some more vague characters come through the courts that maybe their features can't be described so easily into 5 different identifiable and original characteristics, because only then will we kind of get an idea of where the bar is for copyright in a character, because it's almost certainly not as high as Del Boy. And then I kind of said this before, but parody needs to have a target, and he also made the comment that it's very difficult to satisfy the requirements of parody if the resulting work and if the original work is comedy, because it's already humorous. Okay, I'll hand over to Toby.
I'm pretty sure that what I've got to say after all of that is going to feel like the sort of 2-minute human interest piece at the end of the 10 o'clock news, because I'm not talking about a case. I'm talking about what was a proposed text and data mining exception, which has now been abandoned, which feels like quite a tough gig, but I'm going to give it a go. And the reason we're going to give it a go is because it's not so much the exception itself which is interesting, although it is. It's really the context in which it sits, which is kind of AI, which everyone's talking about. So here goes. So the UK had a text and data mining exception proposed recently. We'll come on to it in a moment, but I thought as a prelude to that, we should probably think about what text and data mining actually is. And there is no agreed definition on this, but what we do have is a definition in the Digital Single Market Directive, which is up there on the screen, and it just really describes what text and data mining does. But obviously, as a prelude to text and data mining, you've got to forage for the information first and get it. And that's where the exception is relevant, and that's why it's important. Why is it important? Well, the UK adopted a national data strategy in 2020. And under this strategy, data and data use is seen as an engine for economic growth, and it forms a central part of the government's ambition to create a fast-growing and thriving data economy. The mantra that you repeatedly read in these documents is about unlocking the value of data. And so it's a policy priority of the government to make sure that data is available and, and to essentially just make sure that it's accessible, mobile and reusable. And it's the accessible part of that equation that we're sort of interested in here. You also have the National AI Strategy, and it was in the context of this strategy that the government issued a consultation and a call for views on artificial intelligence and IP. And essentially, within that, they proposed a text and data mining exception. They threw forward a bunch of options. It was about 4, from a really stingy one to a really generous one that meant that AI developers would do what they want, basically. And it was in response to that consultation that the government put forward the exception. We'll come on to that, as I say, in a moment. Existing exceptions that we have under UK copyright law, which might be relevant to text and data mining. Well, there's section 28A. That's what we sometimes refer to as the temporary copying exception. And that's useful because potentially, if you're, for example, sending a bot out onto the internet to scrape loads of websites, but you're only keeping it on a temporary basis to train your AI model, for example, and then disposing with it, you might be able to argue that it's a temporary copy. That might not get you home because you might want to keep that copy for validation and verification purposes, especially if you're training an AI model. So it's not actually been tested in the courts as to whether Section 28A would be particularly applicable or not. It may get an airing because recently Getty issued a case against Stable Diffusion, which is a text-to-image transformer model. So you can type in silly prompts and you can get a crazy image, and we'll come on to that next. Ultimately, well, I think this case, we don't have the court documents on it yet. That's the first point to note. So there's no accessible court documents, but I would be surprised if Stable Diffusion don't argue that the temporary copy exception might apply. Oh, it's a test case, so you'd think that they'd run every argument possible. And the other one is section 29A, and that is the text and data mining exception in the UK, which sounds great. We introduced it in 2014, but it's very narrowly circumscribed, so you can only really rely on it if you're doing text and data mining for non-commercial research, essentially. So it's very limited. So why is it relevant? It's because we can do crazy stuff like this. So this is a picture that I rendered. I won't say create. I rendered on Stable Diffusion by typing in a prompt, which was a monster emerging from the ocean in the style of David Hockney. And that's what I got. And the reason that Stable Diffusion can produce that is because they have taken tons of images and text from the internet and probably other places, trained up their model with it. That then reduces it into a different format, and then I can type in my silly question and it will produce this. So that's interesting. I'm going to slightly digress from the topic of this theme at the moment, but this isn't really relevant to the exception, but I can't resist putting it in there. So I typed in a question into ChatGTP. Vaingloriously, I said, "Tell me about Toby Hedden, Senior Associate at Bristow's Law Firm." And this is what it produced. And you don't need to read it. The point is that everything shown in red is incorrect. It's false information. Whereas everything not shown in red is true, which is quite striking, isn't it, really? But I suppose it illustrates that these multimodal models are only really as good as the data that's in them. And obviously, it's not got much data about me, so anything that I type in about me comes up wildly inaccurate. Anyway, sorry, back to the theme. So let's talk about the proposal itself. In short, it was planned to apply to both copyright and database right. It was intended to cover text and data mining for any purpose, so commercial purposes. The only real requirement is that you needed to have lawful access to the data, however that is. It wouldn't be open to right holders to charge a license fee. And so far, this is looking very much like the Article 4 text and data mining exception in the EU Digital Single Market Directive, which is broadly very similar. But where it differs is you have an opt-out provision in Article 4 where rights holders can say, but we don't really want to, license our data on that basis, so you can't rely on that exception. Here, they said you can't contract out of it. So what the UK did was went nuts and went for the really broad, generous, massively helpful exception to all AI companies. And understandably, rights holders got a bit excited about this and said, well, hang on, this is going to decimate the creative industries. You're basically giving them carte blanche to take all of our stuff and not pay us a bean. So that was a concern, and I think the UK IPO had a lot of resistance. They had this idea that it would render benefits to AI developers, SMEs, journalists, citizens, cultural heritage institutions. They always crop up, don't they, in these sorts of exercises? And I think ultimately they hadn't really properly thought it through. They'd done no impact assessments, and they met with very fierce resistance from the creative industries, as you pretty much expect. I've just put some pros and cons up here. Obviously, if you think about rights holders, they have existing data licensing models which already license out data for these purposes. What would happen to those? If you had this big exception come in. It's also a nascent market in certain sectors as well, so it would sort of be squished before it had a chance to develop. And that was another mantra that the right holders and creative industries, I think, were advancing to say, look, let's get this off the ground. We are looking after this area. There is not a market failure here. It just needs a chance to grow. And there was also a big question around whether it's compliant with the three-step test. And that's part of most international copyright instruments like the Berne Convention, the WIPO Copyright Treaty, TRIPS. It's also in the EU Copyright Directive, and it's a sort of part and parcel of EU law. And that's essentially an argument that was put forward by right holders when they were complaining to the UK IPO about proposing to introduce this huge sort of broad exception. On the positive side, it obviously circumvents the problems with getting authorizations. You can just go and take what you want and not pay for it. There are the likes of YouTube already sort of factor into their terms of use that they can use the video that you upload for X, Y, and Z purpose. But obviously not everybody is YouTube. YouTube is very large and pretty much has a very strong bargaining hand to play. So the idea that you have this very broad exception would certainly level the playing field a bit for some of the smaller players. Hence the second bullet point, it overcomes asymmetries in bargaining power, avoids transaction costs because you don't have to enter into licenses, and I suppose also provides some certainty. I think anyone who knows copyright law who saw this when it came out thought this isn't really going to fly because it was just, I wouldn't say, it's harsh to say it's ill-conceived, but they hadn't really done proper assessments or thought it through. And I think it was a very ambitious attempt to bring in a very broad exception on the wave of AI friendliness and wanting an economy which is built around AI. So where are we now? Well, George Freeman announced in the House of Commons, I think it was in February, that the government would not be proceeding with these proposals. Essentially, the creative industries had, made their voices well heard before the Comms and Digital Committee, and the government had listened. I don't think at the moment there is any plan to restart the process or the negotiations. I would be surprised if it stays that way for too long, because at the moment the UK is at a distinct competitive disadvantage with other places. So the US, for example, have the fair use doctrine for copyright, which is a very fluid and broad doctrine which allows them to determine whether they think a particular use, such as scraping data, is actually fair and therefore usable. The EU member states have Article 4 of the Digital Service Markets Act, which is the slightly broader exception but with an opt-out. In the UK, we're just left with Section 28A and Section 29. So that's where we are. Watch this space. Thank you very much.